Hello, everyone, and welcome to Neuroscience and Criminal Law, the post-Jones landscape for late adolescents and emerging adults. My name is Carmel Shafar. I'm the Executive Director of the Petrie-Flom Center for Health Law Policy, Biotechnology, and Bioethics at Harvard Law School. This event is part of the Project on Law and Applied Neuroscience, which is a collaboration between us and the Center for Law, Brain, and Behavior at Massachusetts General Hospital. I strongly encourage you to look up their fantastic work if you're coming from the Petrie-Flom side. If you are coming from the CLBB side and might be interested in what Petrie-Flom does, I encourage you to sign up for our newsletter, which comes out twice a month. Read our blog, The Bill of Health, which aims to host interesting health law, bioethics, health policy conversations, as well as check out our upcoming events. But before that, let's get to the event at hand. We are so excited to have you join us. There will be a moderated Q&A at the end of this event. I encourage you to submit questions to the speakers. How do you submit questions, you might ask? Well, the best way is to use the Zoom Q&A feature found in the meeting controls at the bottom of your screen. If for whatever reason using that is not right for you, you can join the conversation or submit questions on Twitter to @Petrie-Flom using the hashtag #LawAneuro. Again, that's hashtag #LawAneuro. In the meantime, if you have any technical issues, please feel free to email us at petrie-flom@law.harvard.edu. We'll be monitoring that inbox and jump to your aid. Now that the housekeeping is over, I want to plunge us straight into the meat of this discussion. And with that, it is my honor to introduce our panelists. I'll go in order of presentation. The first is Stephanie Tabashnik, who is a psychiatrist as well as a lawyer. She's got dual training. She is our senior fellow in Law and Applied Neuroscience, which is a joint fellowship between the Center for Law, Brain, and Behavior, as well as the Petrie-Flom Center. She will be joined by Lael Chester, who is the director of the Emerging Adult Justice Project at Columbia University's Justice Lab, followed by the Honorable Jay Blitzman, who is CLBB-affiliated faculty and lecturer at Harvard Law School, Northeastern Law School, and Boston College Law School. With that, Stephanie, this is such an interesting and important topic. I am delighted to hand it over to you.
Hello, everyone. It is great to be here. I'm going to be covering a lot of ground, and I just want to let you know that my slides are available after this, so feel free to send me an email and I can send them along. So for part one, my section, I'm going to be talking about developmentally tailored justice briefly. I'm going to be discussing neuroscience as related to the pre-Jones landscape and the post-Jones landscape. I'm going to be talking about different court decisions and also the implications for all of this. So I just want to plug two really great resources before I get started. The first is a white paper on the science of late adolescence, which was published by the Center for Law, Brain, and Behavior just earlier this month. And then the second resource is still in press, but it's by Francis Shen, and I had the honor of reading an advanced copy. It's a really phenomenal article, and it's looking at the developments, the post-Jones, and the use of neuroscience to extend the Eighth Amendment Miller protections to defendants over the age of 18. So these are two great resources that I encourage you to check out. So developmentally tailored justice is sort of justice that examines the sort of developmental factors of juveniles and adolescents and young adults to sort of tailor to their specific needs. And more about this, but some examples are, raise the age, extending the age of juvenile court jurisdiction to young adults, so those who are over the age of 18, specific rehabilitative interventions that are more likely to be helpful for those in the young adult range, diversion programs, and also special young adult parole hearings. And I'm going to be using some terms interchangeably. So when I'm talking about those who are 18 to 21 or 18 to 24, I'm going to be using late adolescence, young adult, emerging adult, because there's no consensus on what term should be used in discussing this population, and all terms are used in the literature. Lel's likely going to be talking about this more. There's also, when considering developmentally tailored justice, there's a number of initiatives to create developmentally sensitive courts for young adults, and these include courts that integrate neuroscience and young adult or late adolescent neuroscience. And this is specifically the San Francisco Young Adult Court has really integrated brain research and behavioral research to promote better outcomes for this unique population. And these three courts, there's different ways to qualify the court for the court. Some it's just misdemeanors, some it's certain enumerated felonies, all cover 18 to 24. And then the Chicago Restorative Justice Community Court actually goes until age 26. So there's actually a long history of treating young adults differently. And it wasn't until World War II that the age of military conscription was actually raised or lowered from 21 to age 18. So prior to that, sort of the age of maturity for military conscription was age 21. And also the voting age prior to 1972 was 21. It was only in 1972 that it was lowered to 18. So we also have ways that we treat young adults differently under federal law. This includes the drinking age being 21, not 18. If you want to open a credit card, you need a cosigner until you're 21. Under the Affordable Care Act, individuals can stay on their parents' health insurance until they are 26. And in some states, parental support obligations can extend past the age of 18. So again, these are all ways that we're treating this emerging adult population differently, at least under federal law. And there's and each state has different laws that may treat this population differently as well. So I'm going to briefly touch on the neuroscience because that's a key part of our talk today. And I want to say that a lot of the research that's focused on adolescents, a lot of the neuroscience research on adolescents, the findings have been shown and been demonstrated to also apply to late adolescents, so those who are 18 to 21, or in some cases 18 to 25. So the takeaway from this is really that the late adolescent brain or the young adult brain, it tends to be more neurologically or neurobiologically similar to adolescents than it does to those who are over the age of 21, so more older adults. So I'm going to talk briefly about hot cognition and cold cognition decision-making. So we know from the literature that late adolescents, so those 18 to 21 are, and adolescents actually as well, are, they do pretty well in terms of cold cognition context. So cold cognition is, decision-making that is used when someone has the chance for deliberation and time. There's not a lot of pressure in the immediate moment to make a decision. And like I said, adolescents and late adolescents tend to do as well as adults. Now in hot cognition contexts, which are high emotionality, a lot of stress, uncertainty, chaos, adolescents and late adolescents tend to make poor decisions. And when you think about sort of the circumstances that involve, first-degree murder and second-degree murder cases, these cases tend to happen in more of a hot cognition context. So, the majority of these murders are not super well planned out, deliberative homicides. They tend more to be sort of, spur of the moment, drug deals gone wrong, not to minimize the crime, but more of a hot cognition as opposed to a cold cognition context. We know that adolescents and late adolescents are primed to seek they're sensation seeking, they have a preference for risk, they tend to be highly sensitive to threat, they tend to sort of live in the moment. The adolescent and late adolescent brain is more geared towards the present as opposed to thinking through the consequences of their actions in the future. And the presence of peers increases risk-taking behaviors in a way that is not present for, or not as present for adults. And, sometimes courts don't I think fully appreciate that it's not necessarily about peer coercion or peers only sort of having an influence if they're coercing or influencing behavior. Just mere peer presence increases risk-taking behavior. And in many states, as you may know, It's a driver who's 16, 17 cannot drive with another peer because they know from accident data that it increases the risk of poor driving or risky driving. So, and all of these factors have a positive basis in our evolutionary history, and we're adaptive, but in certain contexts, they're less adaptive. So this isn't to pathologize adolescence or late adolescence. It's just to say in these, this is sort of your brain wired on adolescence and late adolescence. And the positive is that adolescents and young adults are very resilient. And when they're given a chance to engage with pro-social peers or peers who make good decisions and given support, including the influence of just one supportive adult over time can be really helpful for this population. Access to meaningful opportunities, provided with a safe environment, and given a chance to really increase their self-efficacy, this population does really well and is tremendously resilient. And we know that even adolescents and late adolescents who create or commit serious crimes, including homicide, the vast majority do not, or the majority do not go on to commit further crimes or engage in further criminal behavior. So the most adolescents and late adolescents desist from criminal behavior. So I'm going to shift to the sort of trifecta of legal cases involved in this area, and then we'll also talk about Jones. But the takeaway from this is really that when looking at Roper, Graham, and Miller, children as a class are being treated as constitutionally different from adults in their level of culpability. So I don't want you to read all of the slides, and I'm happy to send it to you. I just want you to focus on the bold. So we know that Roper v. Simmons in 2005 barred the execution of juveniles as a class. And, I think this is a good reminder that it was less than 20 years ago that we were still executing those who were 17, and 16 years old, and that we're still executing those who are 18, 19, 20. So in Roper, there was a reliance on, scientific and sociological studies. They talked about a lack of maturity, impetuosity, ill-considered actions, reckless behavior. And then in Graham v. Florida in 2010, when we saw the barring of life without parole for non-homicides for juveniles, there was a reliance by the court on developments in psychology and brain science. And, they talked for the first time really specifically, or, at least made a nod to the fact that the brain is involved in behavioral control and that this continues to mature throughout late adolescence. In Miller v. Alabama in 2012, which barred mandatory life without parole for juveniles for homicide. In footnote 5, we saw references to developmental psychology and neuroscience, that brains are not fully, mature at the age of, adolescence. And there were also references to numerous post-Graham studies. So then we got to Jones v. Mississippi, which was sort of a pivot from, the sort of developmentally sensitive trend, which said that life without parole sentences for juveniles really only require considerations of youth as a mitigating factor and do not require a separate finding of permanent incorrigibility. And what was striking, I think, in this opinion is that there was no reference to neuroscience and social science. And we can think about why this was. I mean, the Roper, Graham, and Miller court was significantly different than the Jones court, but I think this was really interesting and a departure from previous Supreme Court cases on this topic. So post Miller, and this is a citation from the Shen article, which again is fabulous and will be released later this year. Miller has been cited in over 5,000 court cases. And in 494 cases where the defendant was over 18, they substantively discussed neuroscience and argued for an extension of Miller protections to those over age 18. Now, it's notable that none of these petitions were ultimately successful. So at least, in these cases, the neuroscience was not especially persuasive to the courts. And I would say, in terms of trends, the federal court and the Supreme Court generally have found neuroscience arguments unpersuasive in this topic as of late for extending protections to ages 19 and 20. The states is likely going to be where the battleground emerges. So this is a really important case. It's out of the Supreme Court of Washington in 2021, for those of you who are not familiar. It's a Munchkin case. And this case said that mandatory life without parole sentences are unconstitutional for offenders younger than 21. And what was really interesting about this opinion is the court heavily relied on neuroscience in a way that hasn't especially been seen in previous Supreme Court cases, and especially Jones. So the question at bar in this case was whether the constitutional requirements that prohibit mandatory LWOP for those under the age of 18 also prohibit mandatory life without parole sentences for defendants 18 to 21. And notable is that in the majority concurrence and dissent, the word brain was found nearly 24 times. Neuroscience or neurological was found 13 times. And I'm going to go through this case. And again, I only want you to focus on the bold because there's too much text, but really to highlight the influence of neuroscience in this particular decision. So the court said the court is referencing biological and psychological development and that it continues into the early 20s, citing to numerous scientific studies. They're talking about, the court is discussing in the opinion, general differences between juveniles under the age of 18, which were recognized by Roper. They're saying that this is also present per the research in the neuroscientific and behavioral science literature in people older than 18. They're talking about the developing brain. They're talking about all of this is constitutionally significant. I wanted to call your attention to a heading, which doesn't mince words. The heading in the opinion was no meaningful developmental difference exists between the brain of a 17-year-old and the brain of an 18-year-old. So I think that's striking. That's quite the statement that the Supreme Court of Washington majority opinion has rendered. There's also a highlight of no meaningful neurological bright line exists between those who are between the age of 17 and 18, and also 19 and 20 in terms of brain development. And this is, I think, true. And I would say even neuroscientific, from a neuroscientific standpoint, there's a lack of consensus on when the brain matures and when different brain processes mature. But from population data, the research suggests that the brain is not on average fully developed at the age of 18, and that 18 is not a bright line where the brain automatically changes or rewires. The court also nodded to the general to individual problem, the so-called G to I problem. So when we're talking about neuroscientific research and also neuroscience research and also behavioral science research, we're focusing really on group data. So we're not talking about individual brain scans. We're talking about the brain on average using using a sample. And the court, those that oppose to the integration of this literature into sort of the court's decision making say, well, this science doesn't apply to the individual defendants because we don't know what the individual defendant's brain looks like as compared to the population data. And we're also sort of years off from potentially making that comparison in a way where there would be some sort of scientific consensus about the implications of those differences. But the court said, okay, that's exactly why we need to be able to make an individualized decision for a youthful offender and not have mandatory sentences for this population for those who are 19 and 20. So again, the court says there's no meaningful cognitive difference between 17-year-olds and many 18-year-olds. And the court says that, in remanding the case for a new sentencing hearing, that the trial court must consider whether each defendant was subject to the mitigating qualities of youth. And the court held that these 19 and 20-year-old petitioners must qualify for some of the same constitutional protections as well. And you can see in the sentence below or above, the court is referencing, again, very specifically neuroscience and the developing brain. Now, in the dissent, which I think is a fair critique, the dissent says, and the dissenting opinion basically says, where do we draw this line? What age do we stop? Because brain development, with the brain development evidence, do we stop at 20? Do we stop at 22? Do we stop at 25 for applying Miller? And eliminating mandatory life without parole given the brain science. And I think that's a fair question. And I think there's at present, there's no consensus in the neuroscience community on where the line should be. And I think that's really at this point, a legal question. So I'm happy to send you my slides if you send me an email, and because I know it's a lot of information, and I'm going to pass this over to Lyle Chester to talk about some of the implications of this and also the current legal landscape.
Great. Thank you so much, Stephanie. So happy to be here with all of you and talking about my favorite subject. From the time that I began working at the Emerging Adult Justice Project at Columbia's Justice Lab in 2016 to now, there's been a remarkable increase in activities in the field. This includes litigation, which Stephanie's talked about, experimentation of specialized practices, and innovative policy reforms. I'm going to focus on two today, the little bit on the litigation, although Stephanie's covered it. I'll just add a few of my own personal takes on it, and the legislation. I'm not going to have a lot of time to focus on innovations and practices, but note, though interesting to date, these practices such as specialty courts, specialty probation, specialty correctional units have impacted only a tiny fraction of system-involved young people and can create justice by geography. Litigation and legislation have the potential, I believe, to be the big game changers. So why has emerging adult justice garnered so much attention and interest in the courts, with the justice system practitioners, and with policymakers across the country? I really think it's because of the robust body of research in the fields of neurobiology, developmental psychology, and sociology, particularly life course criminology. So Stephanie's done a superb job of talking about neurobiology and developmental aspects of adolescence into adulthood, which extend, right, that transition from child to adulthood extends for many years into the mid-20s before you're really truly a mature independent adult. But I also want to highlight the sociological research. We know that when young people have the opportunity and support to grow up and become healthy adults, reaching such key milestones as entering into trusting relationships, getting an education, obtaining meaningful employment, they mature and desist from crime. In fact, the vast majority will age out of law-breaking behavior by the mid-20s, as described by the Center for Law, Brain, and Behavior's new white paper on science in late adolescence. We also know that emerging adults are both failing and being failed by the adult criminal legal system. They are overrepresented from arrest to incarceration, and they have the highest recidivism rates of any age group that touches the justice system. The racial and ethnic disparities, a tragic problem, right, in our criminal legal system today, are the highest for this age group, especially the youngest cohort. Black males 18 and 19 are 11.8 times more likely than their white peers to be incarcerated. The big question is, does treating young people like older, fully mature adults in the justice system support maturity, or does it interfere or even harm normal desistance? Sadly, the research indicates the justice system is causing harm, and that if the system provided fair, effective, and developmentally appropriate responses to this distinct age group, we would both improve youth outcomes and increase public safety. There is, as you heard from Stephanie, no magic birthday that transforms someone into an adult. But if I had to pick a birthday, I would argue that the research indicates that 21 makes a hell of a lot more sense than 18. I'm going to share some slides, and some of these will just be helpful to remind you of the things that Stephanie's already shared with us, right? But we have a series of U.S. Supreme Court cases, as she mentioned, right, that were gaining momentum. And I think for a lot of advocates and a lot of people working towards, recognizing the developmental differences of a youth versus an adult, it was very encouraging. And then along came Jones versus Mississippi last year. And switch my page here. And depending on how you read the majority's opinion by Justice Kavanaugh, or the interpretation of the judicial tea leaves, the court appears to have put a brake on this momentum, or perhaps even started a retreat. So as you heard, there's about this case. It involves a 15-year-old, Brett Jones, who has experienced a childhood marked by violence and trauma. And he was convicted of killing his grandfather, again, at the age of 15, and was given automatically life without parole. Then the Miller decision came down from the U.S. Supreme Court, and Brett Jones went back and asked for a new hearing, a resentencing. And the court looked at it, and as Stephanie said, the judge ultimately decided, no, life without parole. In the dissent of Justice Sotomayor, which was very forceful and was joined by Justice Breyer and Kagan, she pointed out that the facts leading up to the murder, the crime itself, and Brett Jones's behavior immediately after the crime all showed, quote, fundamental immaturity. And it was in its very nature the type of case that for many of us, whether we're steeped in the laws and the research or not, really showed a lot of those markers of what we would think about a 15-year-old, again, who had experienced a history of trauma and violence, and then confronting in an emotional setting his grandfather. I just want to note that in the majority opinion, the court said that the court's decision does not preclude the states from imposing additional sentencing limits in cases involving murderers under 18. So I want to add that I also think that the decision does not preclude states from imposing limits on cases involving emerging adults over the 18th birthday. Stephanie talked about the Washington State Supreme Court case, right, with Munchkin and Bartholomew, and pointed out the language where, is there really any distinct difference between the brain of a 17-year-old and the 18-year-old? And the court called the 18 and 19 and 20-year-olds in the decision essentially juveniles. The opinion was based on state and federal constitutional law and does open the door for other state courts to offer more protection to emerging adults. I'm going to turn now to legislation. There's been an increasing number of bills filed in state legislations across the country that focus specifically on system-involved emerging adults. I'm going to start in the deep end of the system, which is specialized parole or resentencing provisions for those states and jurisdictions that don't have parole and parole boards. These statutes usually include young people, usually up to age 25, though the age ranges can vary. And they're given an earlier opportunity for review by either, the parole board or by a judge. Their review generally includes an assessment of the maturity of the person at the time of the crime and any factors that could have impacted that maturity. For example, parental abuse or anything related to their upbringing, their circumstances, largely out of their control. The statutes also generally call for a review of the growth and maturity accomplished since the crime. So how has that young person done? That was 10, 15 years ago. Again, depends on the statute, how long you wait, but it's generally shorter than other cases. How have they grown? It's interesting because in Justice Sotomayor's dissent in the Jones case, she quotes a defendant and who talks about his own growth. The quote is, "I've done everything I could over the past 10 years to be somebody. I can't change what was already done, but I can just try to show I've become a grown man." These specialized, I should add one more thing. I love this quote from her when she explains in the Jones case, which of course relates directly to the specialized parole resentencing legislation as well. She explains, the question is whether the state at some point must consider whether a juvenile offender has demonstrated maturity and rehabilitation sufficient to merit a chance at life beyond the prison in which he has grown up. For most, the answer is yes. So these specialized parole provisions provide no guarantee of release, right? Folks can still serve a life sentence, but they do provide an opportunity for a review, and they offer hope. Another area of legislation that we see and active in the last few years is around hybrid systems, often called youthful offender provisions, but it has different names for different jurisdictions. And what these various statutes do is they provide a mix of the juvenile system and the adult system, and often they can apply it for youth under 18, but they're more likely these days to be applying it for youth also over 18, the youth transitioning from childhood to adulthood. Examples of these kinds of hybrid statutes are Washington, D.C., Michigan, New York, Vermont, and Alabama. Generally, there's no fast rules, and we're doing a big research project on this, but generally the kinds of provisions you see in hybrid include the elements you include confidentiality, capped and shorter sentences, expungement, and sometimes automatic expungement. Even if you have served time behind the wall, when you're released, your record is expunged. And developmentally appropriate programming, like vocational training or education, is embedded in some of these hybrid systems. A third body of legislation I'm going to point out is expungement. This is a hot topic, especially when you think about the collateral consequences that flow from an adult criminal record, right? The idea is if you expunge the record, you're affording young people the opportunity to be free from these burdensome collateral consequences that can actually extend through life, so that they can get access, safe and stable housing. They can have meaningful employment, right? They can do the things we actually want them to do as adults. And then the last one, which is the one I'm going to focus the most on, is raise the age. Again, Stephanie mentioned this. States are beginning to look at the age range in which they include youth in the juvenile system. And they're looking at it, sometimes we call it right sizing. They're trying to determine what is the sweet spot. What are those ages that we should be serving and responding to young people, right? So for the majority of states, there is no lower age limit. Right. And so states are saying, do we really, a 2-year-old, a 5-year-old, 11-year-old, how does that make sense? Right. So Massachusetts has raised its lower age of juvenile jurisdiction to 12. And then states are also looking at the upper end of juvenile jurisdiction. Most states, except for 3, have finally come to the 18th birthday. Of course, there are exceptions. Younger youth can be tried and or sentenced as adults before 18, but 18 has sort of become the national default. I think it's worth noting, right, that when we created a specialized system for children back in 1899 with the first juvenile court, we were all over the map of what the age was. It ranged somewhere between 16 and 18. And as states started to replicate and create the system in their own states, they picked different dates. And there was a fundamental belief that young people were just different from older people. It would be wrong, it'd be inappropriate to put them in the adult system, right? But we didn't have the benefit of the research in neurobiology, developmental psychology, or sociology, which of course we do now have. I wanted to just, not that you have to look at this in any great detail, but there are fundamental differences between the juvenile system and the adult system, right? And so when you think about like adding a specialty court, that doesn't necessarily address these fundamental differences. And so this is just a list of differences that we see in Massachusetts, right, between the juvenile court and the adult court. Yes, they're trying to hold youth accountable or people accountable. But in the juvenile side, right, the explicit goal is rehabilitation. And the adult side, it's usually deterrence and retribution, right? Those are the things. In the Massachusetts system, they have formally adopted positive youth development as a framework, right, in the juvenile side. One of the biggest differences is a juvenile, you're adjudicated, and the adult side, you're convicted. Those are not just different words, right? They have different meanings. So the list can go on. You know, if you're in Department of Youth Services, we don't have solitary confinement. You have sort of a more developmentally appropriate room confinement that is very short. There's a person around, et cetera, versus the adult system. So these are just examples of sort of when states are thinking about, a high school age youth, 18, 19, 20, where should they be treated? What would make the most sense? These are the kinds of things that people are assessing. So where are we today on Raise the Age? We have one state, Vermont, which enacted legislation that raises the age gradually to the 20th birthday. Already 18-year-olds have been included in their juvenile justice system, and that is going remarkably smoothly. Right. These are the other states. Massachusetts, I bolded because we're in Massachusetts. Virginia is brand new. They just filed legislation within the last couple of weeks that would raise the age to the 21st birthday. I want to say, and again, Stephanie mentioned this, right? You know, there's no magic birthday. Where would we go? But I would say that 21, right, is really becoming 18. We see this with the extension of juvenile corrections in Oregon and Washington to 25. We see this in this trend to expand child welfare service past 18. We see that in pediatric care guidelines, right? Pediatric care is to 21 at a minimum or beyond. So these are the types of things that we see. And some of that is that childhood has changed, right? The degree to which people sort of reach those key developmental milestones that into adulthood have been extended in recent generations. I'm going to stop sharing, and I'm just going to say, just to very quickly wrap up, is that I think the future of litigation is unclear. I don't have high hopes for the U.S. Supreme Court in the near future, but I also don't think that the Washington State Supreme Court will be alone for long, right? I think other state courts are going to follow and find that automatic juvenile life without parole for youth up to under 21 is unconstitutional. I think the future of the legislative reforms seem much clearer to me. I believe that a handful of states will soon join Vermont and raise the upper age of jurisdiction over the 18th birthday. Why? Because it makes sense. The juvenile justice system already exists, right? It's hard to create a third system. The juvenile justice system has expertise and developmentally appropriate services. There are many 18, 19, 20-year-olds who are in high school or should be in high school. The adult system can be traumatic and harmful. And the collateral consequences that flow from an adult conviction prevents young people from reaching the developmental milestones that lead to desistance. So if a state already has a YO or a youthful offender provision, now would be the time to expand it to age 25. And if it's a state like Massachusetts, whose juvenile justice system is not perfect, but has officially adopted positive youth development framework and seeks to provide developmentally appropriate responses, those states should raise the age to 21. Thank you.
So good afternoon. Jay Blitzman here. This is a tough duo to follow. My task is to try to connect what you've heard to practice. I just want to begin by sharing an observation. I think based on what you've heard from Stephanie and Lael, it's clear that there's an alignment between developmental and scientific research, which demonstrates better outcomes, not only for youth, but for public safety, with dramatic reductions, I should add, in racial and ethnic disparity. And I'll get to some of that research soon, but in order to illuminate some of the points, as a storyteller, being a former trial attorney myself, I'd like to show a clip from a film that some of you may be familiar with. Laura, can you share the clip, please? Some of you may recognize that clip from Shawshank Redemption. It's, to me, the most compelling and important part of the film. On March 9th, 2020, I had the privilege of going behind the walls at the Correctional Institute in Concord, Massachusetts, known locally as MCI Concord, to speak to a group of approximately 65 men as part of my ongoing restorative justice reaching out beyond the walls. Now, many of those persons had committed crimes, a number of, including murder, after the age of 18. I began my presentation by asking, how many of you have seen Shawshank Redemption? So of this approximately 65 person group, virtually every hand shot up. Everybody's favorite scene was the one I just shared of Morgan Freeman depicting the character of Red in the movie during his second parole hearing after he had served 40 years. And he was no longer the person that he had been when he was incarcerated. It's a story that illuminates and graphically demonstrates the process of natural desistance, that we age out, all of us age out of our most impulsive behaviors. As Brian Stevens has famously observed, each one of us is more than the worst thing we've ever done. But for these 65 odd men, their lived experiences are not movies. Each one has a story. When Robert Kincherf and I testified before the Massachusetts legislature in support of raising the age of juvenile court jurisdiction in this state to 21, my dear colleague used the phrase, "Let's follow the science." That's my message to you all this afternoon. Let's follow the developmental science, the neurobiological science, and apply it in a way that connects to practice and creates better outcomes, obviously, not only in promoting positive youth development, connecting adolescents and young people to the socially connective tissue that they need, but also by dramatically reducing recidivism at significantly less cost. Recent studies done are starting to show with unanimity that connecting young people to community, less detention, reserving detention for only palpable public safety threats is the best way to protect public safety. The Pew Charitable Trust, 2015, Reexamining Juvenile Incarceration. Pew Charitable Trust studies from 2019, 2020, showing innovative attempts to change the approach to how we address young people in states including South Dakota, Hawaii, Kansas, the Close to Home initiative, one that Lael's very familiar with through her work with the Columbia Justice Lab, documenting the very, very positive public safety results that have occurred in New York City after closing upstate New York state juvenile prisons and moving towards a more community-based model. Stephanie and Lael have talked at length about the Supreme Court jurisprudence. I just want to focus on one part of Jones versus Mississippi. A lot of people are very, very concerned, understandably so, by the Supreme Court holding in that case, no longer requiring a finding, or not requiring a finding at sentencing of permanent incorrigibility in order to justify a juvenile life without parole sentence. But the Supreme Court left intact the important construct of transient immaturity. So our challenge as practitioners, as advocates, as scientists, in order to enhance outcomes that are better for young people and public safety in the process, are how to incorporate this concept into practice. That's our challenge. Now, the Supreme Court in Jones versus Mississippi, they established the ground floor. That does not preclude any state from setting its own ceiling. I share Lael's sentiment that perhaps the most encouraging and most, I think, important route to follow is raising the age of juvenile court jurisdiction. I believe it's the most that's developmentally aligned with the science. It connects directly to the Munchkin, and there's a companion case in Washington State called Bartholomew, which, as has been noted, concludes that there are no developmental differences that are significant between a 17-year-old and a 19-year-old. In terms of applicability of this thinking, there are test cases that are developing. There are actually two now that have been heard by the Massachusetts Supreme Judicial Court, which have been remanded for fact-finding on this very issue about extending Miller versus Alabama hearings to the 18-plus-year-old cohort. In fact, Robert Kinshriff was an expert witness in one of these cases. Commonwealth versus Mattis is a companion case called Commonwealth versus Robinson, and we're awaiting the outcome of those cases in Massachusetts. As has been noted, there is pending legislation to raise the age of juvenile court jurisdiction in a variety of states. Massachusetts will be, that bill is pending. It will be heard again in April of 2022. Connecticut, Illinois are also exploring raising the age. And raising the age from 18 to 21 makes good sense given what the experts such as Lawrence Steinberg and Robert are testifying about, and that is applying what we know about the age crime curve, the ages between 18 and 21 to practice. And we see that the peak of acting out behavior dramatically is decreasing during this period of time, that there's a peak and then there's a decrease. So we know this, and the challenge now is to apply it. In terms of each state being able to set its own ceiling, either through expanding Miller versus Alabama hearings or through and via interpretations of their state constitutions and their interpretations of what constitutes cruel and unusual punishment. I give you some other examples. In 2014, in State versus Lyle, an Iowa case, the Iowa Supreme Court determined that under its construction interpretation of cruel and unusual punishment, that mandatory sentencing for transferred juveniles to their criminal system was unconstitutional. The District Court of Columbia in 2020, in the Comprehensive Youth Justice Amendment Act, extended hearings for persons who had committed crimes beyond the age of 18 for resentencing determinations by parole boards for the cohort group of ages 18 to 25. The condition precedent being that a person would have served at least 15 years of the sentence. What's very significant in that statutory framework is the statute, and I'm reading from DC Official Code Section 24-403.03 provides that one of the motivating factors for this enactment in the District of Columbia is the recognition of the diminished culpability of juveniles and persons under the age of 25 as compared to older adults, and the hallmark features of youth, including immaturity, impetuosity, and the failure to appreciate risks and consequences. So I just want to turn again to the raise the age legislation that's pending in Massachusetts. And each state, again, may have a different experience, but in Massachusetts, using this as an example to amplify the importance of this initiative, the recidivism rates of juveniles leaving our Department of Youth Services have hovered around 25% per year. The data from the criminal system shows that 76% of persons released from jails and prisons in Massachusetts are rearranged within 3 years. The one-year recidivism rates are approximately 38%. And while both systems, unfortunately, have issues concerning racial and ethnic disparity, they are much worse in the criminal system. An issue that Lael touched on that I think needs further amplification in this context as regards probation and parole is that when persons are discharged from a state's youth system, whether it's at age 18 in Massachusetts for delinquency cases, or age 21 if we're talking about what we characterize in this state as youthful offenders, they are discharged. By that I mean they are no longer on probation or some form of parole. This is extremely consequential when we realize that the significant majority of persons who are enmeshed virtually perpetually in our systems of mass incarceration are coming out of jails and prisons are in some form of probation and or parole. If you're discharged from a system, that issue of continued surveillance no longer applies. I should note that in Massachusetts, in our DYS system, they have a program called Youth Engaged in Services. YES is the acronym, and over 60% of youth coming out of our DYS system voluntarily seek services through this initiative from the Department of Youth Services, which shows you that the department really walks the walk about positive youth development and maintaining the socially connective tissue, or trying to support that, including educational continuity, which is critical not only to positive youth development, but also dramatically improving public safety outcomes. I mentioned earlier the 2015 Pew Charitable Trust study. It's called Reexamining Juvenile Incarceration. That study notes that the cost of community supervision in South Carolina, as an example, was $6 a day. The cost of detention is upwards of $475 a day. So that's a tremendously differing exponential. We've known for years that states that put more juveniles into adult correctional systems have the highest recidivism rates. Work by Donna Bishop looking at the Florida system, Jeffrey Kagan looking at studies of New Jersey and New York have demonstrated that. We have the science. Now our challenge is to apply it to practice. And I welcome the opportunity to listen to any questions you may have and to further engage in this critically important conversation. I want to really thank the Petrie-Flom Center and the Center on Law and Brain and Behavior for making this conversation possible. Thank you.
So we have several really good questions. One question was asking about how the 3 young adult courts were created. And I would just say that I'm happy to answer this one. I don't know if Lal and Jay want to add, but so a number of the young adult courts were funded through the DOJ, the state, and then also through federal grants. The Brooklyn Young Adult Court in particular was created in partnership between the New York state court system and the Brooklyn DA's office. So that was one question. Jay and Lal,
so let me jump on this first, because as regards this model of so-called youth courts for late teens and emerging adults, and I think Lal, could amplify, has greater detail. There's tremendous variability in these models. I caution against some of these models as providing nothing more than what I would characterize as a crude youth discount, as opposed to listening or hearing these cases within a juvenile court system, for example, which already has the infrastructure to look at issues through a developmentally appropriate lens, which would include a robust system of due process. In other words, that it's not a glorified plea or dispositional system, and a statewide court clinic system, and a very rehabilitative youth correctional system as exists, for example, in Massachusetts. So I know some of these models anticipate a plea. They become sort of intensive probation supervision programs. My concern as a public defender for 20 years before I was a jurist for 24 is a balance and whether or not due process is really factored into these so-called models. So
Jay, there's a follow-up question.
I'm not to say that some are not worth pursuing, but those are caveats that I would raise.
Okay, so Jay, there's a question about the Springfield District Attorney's Emerging Adult Court and whether, to what extent that falls within sort of the spectrum, where that falls on the spectrum you were just discussing.
Well, I don't really have enough firsthand knowledge, so my knowledge is anecdotal, but I have heard from advocates some of the concerns that I just expressed, that it's really not I envision, my envision of a specialty court is what I would call the due process court, one which has balanced accountability. You can have both. You have balanced accountability, but it's proportional. And I think that's the key, and that's a key thing in this conversation. What I've heard about this model is it essentially is you plead guilty, and then we try to be sensitive in terms of sentencing. Now, I might be mistaken, and I would welcome correction or redirection on that. But
Carol, can you add to that?
Yeah, I'll just add that there are these special practices, and especially courts, one of them, and they vary tremendously. Everything from a sign on the door that says emerging adult or young adult court, right? But everything else is kind of the same. You still have a conviction, you're still in the adult system, to something a little bit more like in Illinois, Cook County Restorative Justice Court, that is actually a juvenile judge sits in that session, and it's a true restorative justice where the community comes in, and I think that has, you know, a very different feel. Elizabeth Kaufman in University of California, Irvine, is doing an outcome evaluation study of the San Francisco court, which was pushed by the district attorney, George Gascon, but was a true collaborative court with defense, with probation, with the judiciary, and Orange County. And Orange County is going to be a randomized control, which is not in San Francisco. So that will be interesting to see. But overall, I would say the specialty practices show some promise in terms of sort of making it better and more humane and less traumatic. But it doesn't, is I would agree with Jay, it doesn't change the outcomes. It doesn't, and it may require things like pleas and other things where people are not zealously, defending themselves and their legal rights.
Okay, so we have some more questions. There's a really good question. Do you believe neuroimaging can be used to demonstrate brain maturation? And so this is sort of the G to I, general to individual problem that I had highlighted during my part. And we're really, I think, years off from this. So what we have right now is research that's based on a large number of brain scans. And because there's tremendous brain variability, it's difficult to link sort of it would be difficult to establish sort of whether you have a fully developed brain or a more sort of adult brain, because, you know, different parts of the brain develop differently. And there's, like I said, there's tremendous variability. This also sort of intersects with another question asking about the psychopathic brain. Well, there's, you know, some research on this that I'm not going to get into involving the ventromedial prefrontal cortex and, you know, density, the extent to which there's density related to cognitive control and cognitive and emotional regulation areas of the brain. Because there's so much variability, we're not really at a place where we can put someone on the stand and have a brain image and say this is their brain scan and they have sort of a bad brain. We're just not there.
Yes, science in this area is more probabilistic. And, you know, how do you apply the science to an individual case, I think is part of the challenge. And I think the best we do now is retained experts who can educate juries and other people about some of the issues you've talked about today, Stephanie, adolescent brain development, and then combine that with testing, cognitive testing of individual clients. But I don't think we're at the stage yet we're going to be, hopefully we will be, or we may be someday, of actually introducing brain imaging slides into cases. It's been attempted, but in states such as this, they have not.
Wait, Jay, I want to get to one last question. So, and I think, you know, to the brain imaging, this is why this research fits well for sort of a class of people as opposed to an individual person. So the last question, which I'm going to give to Jay and Lyle, are what are the arguments or impediments to Massachusetts raising the age? And I think it's a big question and we're almost out of time, but if you have an answer.
I'm going to answer, I don't think there are any impediments. I think the impediments are more the people in the system that will have to adjust and change, which is hard, but but we shouldn't be designing our system for the people who work in the system, right? We should be designing the system that is fair and effective and developmentally appropriate for the young people in the system. So I think there are the classic concerns of that's my caseload, or I don't want to add to my caseload. But there's, we've looked at the caseload analysis. Others have probably done even more than the Justice Lab. But there is room, there's capacity. And I think it takes sort of the people in charge to accept the change.
So I just got to say quickly, I second your motion. And I also second Robert's motion. This comes back to following the science. And here again, the science is actually aligned with what's best for public safety. And when you look at the dramatic differences in recidivism and the issues of racial and ethnic disparity, to me, that should tip the scales. So I think that hopefully will tip the scale ultimately. And look, when we raised the age of juvenile court jurisdiction in this state to 18, remember, Lael? Everybody said the skies will fall. Well, the Justice Policy Institute study published in 2017, which looked at what happened in this state, in Connecticut, Illinois, and ironically, given Jones versus Mississippi, which raised the age, at least in juvenile court jurisdiction, said the results were overwhelmingly positive. Not only could the systems absorb the caseloads, but the public safety benefits in terms of reduced recidivism were very, very substantial. So I hope we see the day, and I hope we see the day shortly in this state and in others.
So on that note, and in the Justice Policy Institute study that Jay referred to is an excellent resource. So on that note, we're going to wrap up. Thank you so much for coming to this event and all the wonderful questions, and we hope to see you again soon.
Thank you, everyone.
Thank you so much for letting us share this afternoon with you.